Welcome to a oral argument session in front of the 5th DCA. I'm Judge Jim Edwards. I'll be presiding. Judge Brian Lambert and Judge Harvey J. are with me on the panel. Each side will have 20 minutes for their oral argument. Appellant, typically we reserve 5 minutes for rebuttal. If you want anything different, just let us know and we'll accommodate that. You will see a clock up in one of the panels there. That's the total time. For the appellant, green means you've into your original time, yellow, you're into your rebuttal time. And for both sides, red means stop. If I see you're going long on your rebuttal, I can get a word in edgewise, I'll try to point that out to you so you can decide if you want to keep going or stop. If you have any kind of noisemakers like telephones or a noisemaker on your computer, please put it on silent. I would not turn your phone off in case we lose you. That's how we try to reach out and get you back. So with that, we will now hear case 23-3309, Lerchenfeld versus Green Plus Investments, LLC. So, Mr. Baker, whenever you're ready.
Good morning, Your Honor, Justices. May it please the court. In this case, I've been on this case since the beginning with the first foreclosure and the second foreclosure. We have basically the exact same set of facts, at least the same defendant and same property. And we have two totally different results from two judges from the same circuit. Both of these judges are fine judges, but they came to totally different conclusions. The last thing my client was told was that he would be contacted per the requirements of the HUD regulations before any other action took place. Approximately 3 years later, he finds out that he's being sued and that there's already a case in foreclosure with none of the requirements that the court required in the last dismissal having taken place. That result, besides being unjust, it should not have happened. And there's case law to support our position. As far as I'm going to touch quickly on the de novo review, all of these issues are issues of law for the court, for the panel to decide. Although standing is a mixed issue of fact and law, it's still a de novo review, and it's not the discretion of the judge that's asking to be reviewed here. Specifically, we're talking about the conditions precedent that are required and the HUD regulations that are incorporated in the contract. This is something that wasn't simply us grasping at straws like it was in the Diaz case.
Mr. Baker, I understand the HUD regulations were part of the agreement, but the CFRs, as I read them, say unequivocally, if HUD is not insuring the loan anymore, then the HUD regulations don't apply. So help me understand why that is not a disqualifier of your first argument.
Because the HUD regulations themselves say when that kicks in. Under the effective termination 203.321, it says one of the above have to happen. And those are listed in 203.315B. None of these have happened. In subsection 1, the mortgagee acquires the mortgage property but does not convey to commissioner. They never acquired the property, Your Honor. The property is bid in and acquired at a foreclosure sale by the party other than the mortgagee. That has not happened, Your Honor. After foreclosure, the property is redeemed. That also has not happened, Your Honor.
What about 203-500 that says that the guidelines only apply when the mortgage is insured by HUD? What do you do with that?
Your Honor, termination can't occur unless you've met the requirements of 203.315.
So the answer to my question, what do you do with 203-500? I'm just trying to reconcile these CFRs.
Your Honor, I would say that this is not a right or a privilege. This is a policy and a procedure that was incorporated into the mortgage. it's not simply it's either you're a lender or not, because it was incorporated. That's what makes it different. And that's supported by the Kersey Court in the federal jurisdiction. When they also cite the Baker that came to the same.
Well, and I understand the whole incorporation thing, and I understand there's a differentiation in those cases, but doesn't bringing those regulations into the agreement mean all the regulations are part of the agreement, and all of the regulations include 203-500, which expressly provides that HUD guidelines apply only to mortgages insured by HUD. So I just don't know how that is not, takes away your first argument categorically.
Your Honor, I don't think it does, because it's all under the 203-321. There's no evidence that that ever happened. All we have in the trial record is a servicer saying, well, we don't take loans that are HUD, but we don't have anything to show that it actually met the requirement of the regulation to take away their rights. So if we
help me understand what you just said. As I understand the testimony was we don't handle HUD insured loans, and so that was the only testimony on that issue, was it not?
Yes, it was the only, but that is not an equivocal. This no longer is a HUD loan, and it's also. I mean, I don't want to get into the hearsay in this case, because I believe all of that is hearsay on top of hearsay, Your Honor. And I believe that she doesn't base it on her own knowledge. And one of those conditions had to happen. And there's no evidence that any of those conditions had happened, Your Honor. So therefore, if we use the entire regulation, 500 doesn't come into play because it hasn't happened. Those are the things that are required. And we would still say it's incorporated, that they got to follow the guidelines and they got to follow the procedures. And there's nothing that stops that. Plus, Your Honor, without doing that, you take away everything from all the protections that this mortgage or this debtor has. He has no protections left. So I believe it should be incorporated completely in there, especially since they haven't met the criteria for it to not be, they haven't met the termination requirements. That has not happened, Your Honor.
What about your argument, your third argument under 559-715, that the notice of assignment requirement is a condition precedent? What's your best argument in support of that?
Well, Your Honor, it goes back to at the end of that ruling in the Brandeis case, besides the fact that we believe that's the ruling you're talking about, Your Honor?
Yes, sir. That's Judge Kazam's dissent.
Yes, Your Honor. Besides agreeing with the opposite or the dissenting opinion in that case, just before at the very end, they say we take significant note that these people are protected by paragraph 22, and they go into detail that they're protected by paragraph 22, and then they go into detail is that they have to follow the contract that they entered, as to a reason why they didn't need to have the notice requirement. It's right in the ruling, and that's in the joint on the side that won or prevailed in that. So this case is definitely distinguishable in that matter. And the circuit courts and for the federal courts are all over the place on this issue as to whether or not it should or shouldn't be. Plus, it's not a plain reading of the statute. The statute doesn't incorporate any of the language that they inserted into their ruling, Your Honor.
Well, as I remember, Brandeis, the court did say what you just represented, Mr. Baker, But they also say that even though they're protected, there's a big difference between protection and a condition precedent. Is there any language in that statutory text about a condition of this, or this is a condition precedent, or some sort of remedy if there is a violation in the text of the statute?
I do not believe there is, but it's a requirement. And if it's a requirement, it's a condition precedent. And I think there's also another distinguishing characteristic is that when this mortgage was bought, the mortgage and note were bought, it was already in default. They're not trying to just reclaim their security in this case. It's a debt. They bought it as a debt. So it's very distinguishable. But once it's a requirement, Your Honor, I would say then it's condition precedent. If that notice is required.
Let me ask this, counsel. In Lipari, our court wrote addressing 559.715 that the legislature knows how to create a condition precedent when it so desires, and it did not do so here, referring to that statute. So plain language stuff, and just so you have some context on that panel was Judge Eisnagel, who is our plain language guy around here. We all are actually, but so in other words, your third argument, as Judge Jay is pointing out, is it's not a condition precedent. Lipari was in a student loan. The other cases that are cited pertain to the actual mortgage foreclosures, but still the legal principle is the legislature knows how to create a condition precedent. They didn't do it here. Therefore, it's not your argument that they didn't comply, the appellee didn't comply with the condition precedent seems to have already been addressed by the various appellate courts to your detriment here today. Is that accurate? I mean, you might not like it, isn't that what's happening?
Well, that would be accurate, but I think that they're wrong, Your Honor. And I think that this court, this panel has the chance to correct that, or at least make an exception. But in this case, without that, without the Rule 22 or paragraph 22, and without HUD, my client in this case would be left with nothing. There is nothing to protect him at all. And that can't be the proper result. And I still say that once a requirement is that you must notify of the change, and the requirement is that they have to do it at least 30 days prior to, then it becomes a condition precedent because it's a requirement of the court, or not the court, but of the state. It's a statute that requires it. I don't think that there's a requirement that they lay out all condition precedents, because they don't do that in all cases where they say you must do A, B, C, D for everything. That would be our position on it, Your Honor.
Counsel, let me ask you about your standing argument. You agree that plaintiff attached a copy of the note, mortgage, and so forth, the modification to the complaint, and then at trial introduced those identical original documents, correct?
No, Your Honor, they weren't identical. They had an additional allowance that wasn't attached previously, but they supposedly had.
But it did not. But counsel, it did not take any right away from plaintiff, did it? That allowance?
Your Honor, what it does is materially.
Yes or no?
No, it did not.
Okay, so they had the right then, the same rights that they had at the time they filed the copies of the document when they filed the complaint that they had at trial, correct?
No, Your Honor. They didn't, because it's not established that they actually had the document. The claim that they had the note doesn't match the facts that when they presented the note, it had an allonge on it that they were unaware of.
It had an additional document.
I'm
saying it had an additional document when they introduced it at trial.
Yes. And if they had the note in their possession as they claimed, how is it possible there was another attachment to that document that they were unaware of? It doesn't make sense.
And you proved that at trial, didn't you? What witness did you prove that at trial through, that they did not have it?
Your Honor, I believe it's up to them to prove the standing, that they had standing once it's raised.
Well, the judge found they did have standing. You're saying they didn't, and your basis for that is because there was an allonge attached at the time it was introduced into evidence that was not present at the time they filed a complaint, correct?
Yes, and they were unaware of it.
And
even
based
in
on
their-
that, you're saying because they were unaware of the allonge, therefore they didn't have the paper.
Well, even in their, which didn't come into evidence, but even in their own affidavit, they say they don't have actual possession. They say it's being held by a holding company. So Your Honor, they did not have possession at the time of filing. And they
You admit
say,
you admit they had standing at the time of trial?
yes, I do admit they had standing at the time of trial, Your Honor, but they didn't have standing at the time of filing, which is also required. And even though it did not come into evidence, the court, I think, took note of it. And it was also, but it says they don't have possession at the time.
You want to reserve the rest of your time for rebuttal?
Yes, Your Honor.
All right. Ms. Griffiths, we'll go to you then.
Good morning, Your Honor. Heather Griffiths on behalf of the appellee, Green Plus Investments LLC, Equal Trust Co. Custodian, formerly FBO David Rosenthal, SEPIRA, Your Honor. Today, Your Honor, plaintiff believes that this is a matter on the legal standing of whether the review is a fact-based review or a legal review under de novo. The plaintiff believes that is a fact review and you're looking for an error by the trial court. We believe all three issues presented by defense counsel may be a caveat for the third issue based on that it is a statutory interpretation, Your Honor. Are fact-based issues. The trial court, based on the evidence presented, found that plaintiff had standing at the onset and standing at the time of trial and entered judgment finding that we had standing, Your Honor. Additionally, the court, based on a review of the testimony presented and the evidence entered into evidence, found that the loan was no longer insured by HUD, and then for the HUD regulations no longer apply to the note and mortgage and is no longer a condition precedent. Your Honor, the defense, after plaintiff rest, defense counsel did move for a directed verdict, and at that time, the court advised that he would need additional testimony or evidence to show that the loan is no longer insured. At trial, defense counsel presented no other evidence or facts to show that the loan was no longer insured. My witness, who has been in the industry for 30 years and who is the owner of the servicing company that services this loan, Your Honor, testified that the servicer cannot service HUD loans. She advised that SN does, who was the prior servicer, can service HUD loans, and that they could not transfer a loan to them because it would violate the guidelines, the HUD regulation guidelines, to transfer it to them if it was still insured by HUD. She testified since May of 2018, at least the HUD loan was not insured by HUD because they could have not serviced the loan. She testified that they received the loan through the plaintiff because when the plaintiff bought the loan, the plaintiff gets to direct who services the loan, and they directed the loan to be serviced by their company. They sent a letter to the borrower attesting that they are now the servicer of the loan. It was sent in May of 2018 saying effective May 7th, 2018, they are now the servicer of the loan and that payments can be sent to them directly, and they provided contact information to contact them as the servicer, Your Honor. I believe that was Plaintiff's Exhibit 5, if I'm not mistaken, Your Honor. Additionally, we presented evidence regarding a comment log showing that the plaintiff, SN, transferred this loan directly to the plaintiff, Your Honor, and that the servicer would be Allied. And that was in April of 2018, Your Honor. Based on that information, plaintiff believes they has shown through the statutory regulations that the loan is no longer insured by HUD and it is no longer a condition precedent to the mortgage. The note and mortgage do incorporate the HUD guidelines. Plaintiff is not arguing that. We're stating that it incorporates the entire guidelines and not just HUD face-to-face procedures. And when you take the HUD guidelines as a whole, 24 CFR 203-500 clearly states the guidelines only apply to loans that are currently insured by HUD. My witness testified that she has 30 years of experience dealing with and servicing HUD loans based on her own personal knowledge that a loan is bought out by HUD and is no longer insured by HUD, when it becomes severely delinquent and there is no showing that they are going to recoup their money anytime soon. This foreclosure action is based on a default date of 2013, Your Honor. We're going on 11 plus years of default, which supports the contention based on a failure of the HUD regulations, based on my witness's personal knowledge, that the loan is no longer insured by HUD because it was bought out due to the severe delinquency of the loan.
Can I ask you about the allonge? The fourth DCA says it's an anomalous allonge, maybe not this one, but
Yes.
they talked about. Was there evidence or testimony about how that came to be? I mean, if I'm looking at it, none of the entities involved on that have anything to do with, they're not the original lender. They're not in the chain of the other transfer of the note or assignment of the note. How does this document come into existence? Is there evidence as to how that happened?
No, Your Honor, there was nothing presented at trial or testimony taken regarding the anomalous allonge. The judge.
So your witness, the 30-year in the industry, was not asked saying, hey, not for nothing, look at this thing here. Can you explain it as a longtime veteran in the industry, how one of these pops up completely detached from everybody else in the chain of the loan?
No, Your Honor, the witness testified to the endorsements on the note, and the note being endorsed in blank on page 3.
But she was not asked then about, hey, isn't this a problem with your standing? Here's somebody else who's transferring interest in this note that has nothing to do with who the plaintiff is, and what's your explanation about that? And that was not asked of your witness. That's my question.
No, Your Honor, it was not asked of my witness.
Did you ask the witness?
No, Your Honor.
Or I don't know if you were the trial attorney, but.
I was the trial attorney, Your Honor,
Okay.
and no, I did not ask her direct.
All right. Okay.
Your Honor, going on to my second argument of standing, Your Honor, plaintiff believes that it showed standing at the onset because under the Ortiz precedent, as well as Taylor Bayview loan servicing out of the second DCA, and JP Morgan Chase versus Perez out of the fourth DCA, Williamson Savings Funding Society versus Lassant out of the fifth DCA, Your Honor, and the numerous other cases, standing on the outset, if we present a note certification under Florida Statute 702 that matches the note that was filed with the court and has the same blank endorsement on it, that we have standing our specific endorsement. We believe that the note contained the 3 endorsements on page 3 of the note, which it leads to a blank endorsement at the time of filing, Your Honor, and then the note submitted to the court at trial contained the 3 endorsements, Your Honor. The defense counsel argues Calbarello versus U.S. Bank National Association, Your Honor, in its brief. In that case, I believe it's distinguishable because the plaintiff's note switched out allonges. Originally at the time of filing had a blank endorsed allonge, and then had a specifically endorsed allonge, and then at the time of motion for summary judgment, they inserted a blank allonge to the note. That changed the standing in the argument of standing. That blank allonge did not have any identifiable information regarding the loan, and nobody could attest that motion for summary judgment where that blank allonge came from. So it was overturned on appeal to go to trial for more additional testimony of where that allonge came from. In this case, the allonge that appeared at trial to the note does not impact plaintiff's standing. It is from parties that aren't involved in the mortgage at the time of filing of the complaint. The allonge is not executed by the last entity that issued the blank endorsement by GMAC. There was no change to the blank endorsement on the note. At most, it is an anomalous allonge to the note that does not have any explanation of where it came from, Your Honor. And it does not impact plaintiff's standing. Additionally, Your Honor, I believe that there is more collaborative evidence regarding standing than just being the holder of the note endorsed in blank. As I stated previously, there was a hello letter showing the servicer took over servicing in the loan in May of 2018, Your Honor. She testified that she was asked by the plaintiff to take over the servicing of the loan when he bought the loan. She testified that they have always been the servicer of the loan. We introduced the comment log, Your Honor, which shows that the SN, the prior servicer, sold the loan to the current plaintiff, Your Honor, and that this servicing was going to be transferred to SN. So even if you want to state that that allonge appeared post the filing of the action, it still does impact my client's standing to bring and maintain this cause of action, Your Honor. And then finally, defense counsel argues compliance with Florida statute 559.715, Your Honor. I believe the case law is very clear on the issue. It's not just the second DCA in Paradise. After the second DCA came down in Paradise, Your Honor, numerous other courts, including the fourth DCA and the first DCA, as well as the fifth DCA, citing it, and Lipari, Your Honor, stating that there is no condition precedence for debt collection under statute 559.715, because unfortunately, if Congress intended for that to be the case, they would have incorporated it. Additionally, Your Honor, I would like to point out that Florida legislation did enact a statute to address foreclosure matters. It's Florida Statute 702. There is no notice requirement when they enacted the statute in Florida. And if they wanted a requirement, a mandatory requirement for notice, you would think that the legislation would have put it in Florida Statute 702 when they carefully constructed that statute to require standing requirements, show cause requirements, sell the finality of final judgments, and sell requirements, that they would have incorporated a notice requirement in that statute as well. Many other states around the United States have incorporated mandatory notice requirements in residential foreclosures, including Pennsylvania and New York, and Florida, when they drafted their statute, did not. So we do not believe there is any type of mandatory notice requirements under Florida law at this time for foreclosure. Any questions?
All right, thank you. If there's nothing further, we'll go back to Mr. Baker for your rebuttal.
Sorry, Your Honor, I'm having a little, can you hear me?
Yes, thank you.
I apologize for that, having a little computer issue there. As far as the standing issue, this is more synonymous to Caballero versus the U.S. Bank, where here we have a change to a document, or in this case, an addition to a document, when supposedly they are supposed to be holding the note. They're supposed to have possession. Clearly, they didn't have possession because something was added to the note without their knowledge. And based on the affidavit and the complaint, they acknowledged that they didn't have possession at the time of filing. Both of those eliminate standing. The one reference that she says, because for the limited purposes, the log was allowed in by the court, was simply to say one servicer took over for another servicer and that the loan had been bought by somebody else. But that's not the note, Your Honor. That's not proof of the note. It's not proof of possession of the note, which is required at the time of filing. And they had the burden to prove standing. And in this case, they didn't. And this shows that if they had possession, they would have known about the allonge and it would have been attached to the complaint. And the reason it was attached is because they didn't have it. Your Honor, in this case, the HUD regulation is incorporated in the conditions that would terminate the HUD relation are laid out in the HUD regulation, and none of those conditions happened. So there was no testimony to that it was delinquent for a long length of time, and after that they know they're not going to get paid, and then they can. That was not testified to at court, even though counsel said that, but it was not testified in the trial. But the fact is, under HUD regulations, this is how it's terminated. And then this is the result of the termination. It didn't happen. None of those things occurred. Plus, it was entered into the contract, which makes it a contract obligation. 500 by itself, the subsection 500 by itself is not enough when none of the conditions that would make it no longer a HUD under the HUD authority have not taken place. So if you're going to follow the regulation, you got to follow the whole regulation. And there's nothing, those four conditions haven't been met.
Can I go back to your standing on the anomalous note here? I mean, anomalous allonge. I mean, I'm looking at this fourth DCA case that was cited, U.S. Bank versus Becker, which seems to be directly on point and adverse to your position. Are you familiar with that case? Yes or no? Are you familiar with the case?
Yes, Your Honor, but
Okay. Go ahead. Well, tell me why that's not problematic for you. Basically, it looks like in that case, it was the same thing here. The chain is the chain from the filing to the presentation. There's a note, an allonge that was unrelated to anybody in the link of the note here. And the chain, the courts of the evidence established the allonge was not made by the holder and had no effect. And the statute, anomalous endorsement does not affect the manner in which the instrument may be negotiated. Absent the anomalous allonge here, it seems like you wouldn't be making a standing argument because the copy of the note attached to the complaint was consistent with the original note admitted into evidence at trial, right?
Yes, Your Honor, but in addition to that, the affidavit itself says that he doesn't have possession. So
the affidavit's not admitted into evidence, right?
No,
Yes,
Your
I
Honor.
mean, I know you might not like the answers to my questions, but I think you've told us that the affidavit's not admitted into evidence. So whatever happens before, when you go to the trial, the trial judge gets the evidence that she or he gets and has to rule on the evidence, right?
Well, I believe in the ruling. Yes, Your Honor, but I believe in the ruling. The court did incorporate that because it was part of the argument, and I think the court included that in their judgment. So even though it wasn't presented as evidence, and that's one of the things I pointed out is that nothing had been presented as evidence to show standing at the time of filing. So, Your Honor, there is enough of a problem to make it not clear, and since it's a requirement in a material issue as to whether or not they actually had standing at the time, I don't think that they've sufficiently.
That would seem to be a better argument on a summary judgment, appealing a final summary judgment. Here you went to a trial, the judge listened to all the evidence and reached the conclusion based on the evidence. So, but in any event, the red light's apparently on. So,
All right, thank you. We'll be in recess.
Thank you, Your Honor.